Good morning, everyone. Thank you for joining us for our webinar today on reasonable care, a law firm's obligation to security. A couple of quick housekeeping items before we get started. If you have any questions during the webinar, please type them into the question box and we will answer them at the end. This webinar will be posted up on our website as a recorded version as well as the slides, so please feel free to go to our website to download it after the fact. All of the attendees today will also be receiving a recorded copy of the webinar in their email. So without further ado, I'm going to turn it over to Paul.
Thanks, Robin, and welcome all of the audience to this webinar today. Again, we're going to be talking about a law firm's obligation to security in the context of reasonable care. Any attorneys on the phone understand what reasonable care means. Questions we're going to try to answer for you guys today is how reasonable is reasonable, and what does that actually mean to you in terms of practical cybersecurity? So I'm Paul Caiazzo. I'm one of the co-founders and the principal of TruShield Security Solutions. I have about 17 years of information security experience, ranging across a lot of federal government experience, many law firms, financial institutions, and other organizations that have significant security concerns. My contact information is up on the screen there, and I'd invite anybody listening to feel free to reach out to me either via LinkedIn or email, or follow me on Twitter. I'm always open to answer questions from either a technical approach or a strategic approach, or whatever questions you have regarding cybersecurity, please feel free to reach out. So TruShield is, again, a company we co-founded in 2008. We are based in Washington, D.C. We're a global cybersecurity company with an operations center in India and many international clients as well. We provide a lot of services to the law firm community, including a professional services stack, which includes compromise assessments and risk assessments and security program development and gap assessments, things along those lines. And additionally, we provide managed security services to that same client base, wherein we provide managed security appliances, 24/7 security monitoring, alerting and response, and much more. We take a partnership approach rather than a provider approach, and really all that means is that we're very, very closely engaged with our clients on an almost daily basis, which is to their benefit, obviously, and it makes us much more effective at helping them secure themselves. So today we're going to talk again about reasonable care and why it's an issue for lawyers and law firms specifically. I'll talk a little bit about the scope of the problem, like what threats and what's the threat landscape that you guys are up against. And then we'll talk about what your actual legal obligations are with respect to cybersecurity, what ethical obligations there might be, and the differences between those two. And then what do you actually need to do next? Where can you go from here to set yourself up for success? So at any point in time, if you have questions, please pop them into that question box and we'll address them at the end. So the problem really is this. You are a high-value target. Whether you realize it or not, your law firm processes a multitude of different types of sensitive information. There's much that you guys are processing that the bad guys are looking for, and the historical trends indicate that law firms are actually being attacked pretty common or frequently. It's an uncommon occurrence that the law firm is the target of a breach from an advanced persistent threat or a remote attacker, simply because they know that you guys are processing such sensitive information for important strategic clients that might exist in the financial industry or large Fortune 100 companies or things like that that have very sensitive intellectual property that you guys are processing. So that's the key problem, is that you guys are a target, and there's also a lack of security standards that have been applied within most law firms that we've seen. So it's time to move on. It's time to deal with that problem. So since you're a high priority target, what are they really going after in your environments? They're looking for intellectual property first and foremost. Especially you guys who are patent attorneys or attorneys that are representing any sort of organization that does research and development. That's really what they're looking for. Any sort of IP that they can use to leverage maybe an existing case that you guys are representing a client for, or some litigation, or maybe even a merger or acquisition, or maybe even making a trading decision on some commodity. That sort of information is super, super valuable, and the bad guys know that you're processing it. Happens quite frequently, and we can point to some historical evidence of that. There have been many breaches within the law firm community. In 2011, there was a really interesting breach at a law in D.C. where an advanced persistent threat from China attacked them based upon their representation of a solar panel manufacturer that was competing with some Chinese manufacturers, and some research and development intellectual property was stolen and enabled that Chinese competitor to short-circuit that research and development phase to get straight to go-to-market. And that obviously saved them a huge amount of money and was to the detriment of the U.S.-based organization that law firm in D.C. was representing. It was a big black eye for that law firm. I don't want to name any names, but if you look in the newspaper, you can certainly find out about that. Obviously, personally identifiable information is of course, going to be something that's easily monetized by the bad guys. But I will say that the majority of the time, when an attacker is targeting a law firm, it's more from an espionage perspective than it is from a simple theft of PII, like credit card information or social security numbers, things like that. They still will have access to that if they're able to breach your systems, so it's still going to be protected no matter what, especially from either your employees or clients' perspectives. That information is what it kind of contextualizes cybersecurity down to the individual level, wherein if your personally identifiable information is exposed, that affects you as an individual, and it makes it a more painful experience in many cases. Obviously, case and legislation information is something you guys are processing regularly. And if you just think about the cases that you're working on or the matters that you're working to become cases, if that information were exposed publicly, that would severely hinder your ability to represent your clients. And in fact, if that were to happen, not only would you be in violation of the American Bar Association Model Rule 1.6, you would probably also be in violation of any client mandates that your clients have issued to you. And so there's some significant liabilities there that you need to be worried about as a law firm. Of course, financial information. Any of you M&A attorneys out there that are working on mergers and acquisitions, that financial information could really be the difference between a deal and no deal. And so your clients are obviously going to want you to protect that as the crown jewels that require really, really vigilant and extreme security around that stuff. All that is information the bad guys are trying to get from you on a day-in, day-out basis, 24 hours a day. And the question you need to ask yourselves is, what is a reasonable amount of protection to prevent the breach of this sort of information? And that's a question which is going to be handled kind of case by case from law firm to law firm, depending upon your client profile, depending upon your position in the industry, how high profile your firm is, and how high profile your clients are. But all of that needs to be baked into your overall security strategy. And then from there, a tactical operation plan which implements that strategy in a manner which is repeatable and sustainable and actually works to protect the information that you're trying to protect. So remember that. You are a high priority target, much like everyone on this slide. These guys were all high priority targets, and unfortunately, if you can think back to some major headlines over the last 18 months, every one of them had a significant data breach. Target obviously had one of the biggest data breaches in history that they're still feeling the pain from. I think they just reached a settlement with Visa for the exposure of that personally identifiable information for, I think it was $19 million of fine that they had to pay to Visa. So these costs of these data breaches, they get up there pretty quickly. And every one of the names on the screen had a significant financial liability as a result of the data breach that occurred. The other thing to remember about everybody on the screen is that these are organizations that all have some sort of compliance mandate to implement a security program. And that should say that their security program is probably inadequate to protect the classification of data that they had within their environment. And so that really should be begging the question to you guys is, is my firm protecting information in a manner sufficient to prevent a data breach like what we saw at OPM or like what we saw at Sony or TJX? And if you can't answer that question, you should probably be asking your technology department. Ask your CIO, ask the other partners, what are we doing about cybersecurity? Because it's really the case that nobody's perfect. There are constantly these data breaches happening, and it's more often than not, the organization has no idea that they actually happened. In fact, in support of that, the average across all industries of the amount of time it takes to detect a cybersecurity incident is 210 days. And that's 7 months. And if you had, if you allowed me into your network for 7 months to do anything I wanted without your even noticing, I guarantee you I could steal basically every bit of information that you consider to be sensitive. And so if you can't adequately attest to the fact that your firm has the types of prevention and detection controls in place, you're likely to be somewhere around that industry average of 210 days. 4 out of 5, so 80% of organizations are totally unaware that they've been breached until law enforcement calls them up. That's a terrifying thing to do. That means that less than 1 in 5 organizations can actually do this job themselves, and the rest of them have to rely upon an outside party, such as a managed security services provider like TruShield. What that actually means is that in the course of normal investigations, the FBI might be called into some investigation to look at digital information as a part of the evidence to support litigation. And in the process of doing that, they find indications that there's either information from your firm or from your clients or something along those lines that they found in the course of that investigation that leads them to find that you have a breach within your environment as well. And so they end up notifying you by either a letter or a phone call, and neither of those are things that you should look forward to. That's not a fun phone call to take. Hey, this is Agent Smith from the FBI. It looks like you've been breached. And that's not really something that you want to have to tell your board either. So what that means is that you really need to be doing a good job of improving your detective controls so that you at least know when that worst thing has happened. Because if you don't, the average cost of a single data breach is over $3.8 million, or just about $3.8 million. And that's the average. So if you're a large law firm that processes a lot of information, you could be much more than that. If you're a very small law firm, you could be less than that in terms of a financial hit, but it's still going to be an impact to your bottom line. And I know that partners responsible for driving profit and loss within your organizations, you're going to be looking at that sort of thing and thinking, can I insure against that? What can I do to reduce that risk? What can I do to minimize my liability? And really the answer to that is build a strong and sound security program that covers the main areas that add up to a holistic approach. And we'll talk a little bit more about that in a few minutes. 9% of companies are actually satisfied with the current incident response capabilities. 9%. So less than 1 in 10 organizations really thinks, yeah, we got that incident response thing down. We know what we're going to do when that data breach actually happens. We know how to contain it. We know how to eradicate the threat, and we know how to move on from there. 1 out of 10. So if you're in that boat, you should definitely be speaking to a subject matter expert that can help you build that incident response capability, define it in a plan that is testable, that is repeatable, because that incident response plan, how quickly you're able to detect, contain, and respond to a threat, that's what's going to separate the organizations that are fixing a piece of malware on one laptop versus those that are issuing data breach notifications to their entire client base and causing major reputation liabilities as a result of that. So, nobody's perfect, and not even law firms. In fact, law firms, in some cases, are a little bit further behind the curve for a couple of good reasons. And it's not necessarily an indictment of the skill sets that we typically see within law firms. It's more an indictment of the overall ecosystem of regulatory environments that law firms have to comply with. So while there isn't necessarily one specific regulation that the law firm must comply with from a cybersecurity standpoint, the clients that you guys are servicing all have them. So the financial industry has to be worried about PCI, has to be worried about FFIEC or NCUA or FINRA or the NFA regulations that have just come out from the National Futures Association. There are many regulations that your clients have to comply with, and in most cases, they get passed to you guys in the form of a client mandate, where they're asking you to attest that you've done the right things from a security standpoint. And you also have that model rule 1.6c of the ABA model rules asking you to exercise reasonable care in the protection of client data. Only 1 in 4 law firms will actually admit that they've been breached. And that's not terribly surprising. This is, typically a black eye, and most don't really like airing their dirty laundry in public. However, research by the firm Mandiant, which is one of the leaders in incident response, indicates that 80% of the AmLaw 100 actually have been breached. So 80 of the top 100 law firms in the world or in the United States have been breached. And it's a matter of time, really, for those last 20% in my perspective. Only 20% of law firms have actually had an independent assessment from a qualified expert. And to me, that boggles the mind. I don't really understand how that's even a possibility. When someone needs a lawyer, they don't think, I'm going to represent myself. Or if they do, the law firm community typically looks at that and says, good luck with that. So in the same vein, I wouldn't expect a law firm to do an excellent job at assessing their own security program in a manner that is going to set them up for future success. So really calling in an independent party to perform that assessment from a qualified expert is your step that you need to take first. That's an absolute mandate, in my opinion, because organizations that have that subject matter expertise have likely seen it done right, have almost certainly seen it done wrong, and can help you avoid a lot of pitfalls in between where you are now and where you're trying to go. And that's going to be a leg up for you guys, and it's going to reduce the cost to actually implement a good security program overall. Only 55% actually have a breach response plan. Now, that's over half, which I guess isn't terrible. It's almost a passing grade, but still, there's 45% of the world's law firms don't even have a breach response plan. And so you're going to be scrambling when that actually does happen to figure out, what do we need to do? Who do I need to notify? What laws do I need to worry about complying with? How do I retain evidence so that if I had to litigate, I could? All that stuff should be baked into a breach response plan. And if you don't even have that document, then you're going to be in a world of hurt should the worst thing happen. And the unfortunate part is that it's almost an inevitability. Our security mantra is that it's really the case that if you haven't been breached yet, you either simply don't know that it has happened or that it's bound to happen sometime very shortly. Simply because those risks are growing. Attackers are able to do more today than what they've really ever been able to do. And the unfortunate part is that while their sophistication grows, the sophistication of the good guys, unfortunately, is not advancing at the same rapid pace. Most of the times because the good guys are worried about keeping things operational within their environments, or they're worried about achieving some minimal compliance goal, checking the box, so to speak. And the bad guys aren't really looking for checking the box. They're looking to gain access to data and monetize that access in any way, shape, or form that they possibly can. So attackers exploiting known vulnerabilities, they know that law firms have sensitive client information of high value. They know that you are likely also a little bit behind with things like patching or things like configuration baselines and the application of cybersecurity controls. They know that, and that's it's not something that is a secret to either the bad guys or to the security community at large. So, for instance, we work with a lot of law firms, and I typically find lack of overall holistic security programs that are developed in a really mature sort of format. And that's something which is endemic to the industry that, again, the bad guys are aware of. And if they're trying to attack your client and your client is their primary target, they may realize that you're a weak link in that chain and working on attacking you. So those known vulnerabilities that you're not patching are things that the bad guys can use to get at client information very easily. There are also attackers capable of discovering new vulnerabilities, doing the research to find new ways to break into systems, and that's called the zero-day threat. In addition to creating the vulnerabilities. Those are threats that are going to be much more difficult for an immature security program to be able to prevent or detect. In fact, it's going to be extremely challenging for the majority of law firms to overcome those two things, simply because the majority of law firm security controls that I've observed rely upon signatures and rely upon what's come before, such that the stuff that's coming next you're not really prepared to prevent. And that's an undesirable situation to find yourself in. Attackers capable of creating new vulnerabilities in systems are typically going to be state-sponsored organizations. APTs, Advanced Persistent Threats, are often called. And that really is the organization that is highly resourced, highly dedicated at attacking you or your client, and not simply looking for a vulnerability someplace in the world that they can throw some exploits at and steal information from. They're trying to steal your information. And that's a nuance, but it's a very powerful nuance, because if they're targeting you specifically and they have the resources behind them to pull it off, they're going to keep working until they get into your system, and then once they do, they're going to steal everything they possibly can. And if you think that the APTs are not focused on you or your firm, or you're not interesting enough or big enough or high profile enough to warrant their attention, I'm sorry, but that's flawed thinking. You definitely have interesting and sensitive information in your environment that somebody can monetize, and they will be trying to do that day in and day out. So what does that all mean to you as either an attorney or an IT professional in a law firm? Simply that basic security is not enough. Basic security is usually focused on achieving a compliance mandate. And in the context of a law firm, that compliance mandate, again, is that client mandate. So your client's going to give you a big stack of documents that says, checkbox that you have implemented the security program. You have strong passwords and things like that. And if your approach to cybersecurity is simply looking at those client mandates and ensuring that you can check the boxes, you're not doing enough. It's not a holistic security program that's built on a sound approach. And honestly, that's the only thing that's going to stop you from becoming that next headline. Again, not where you want to find yourself. So what's your duty from a legal obligation perspective? Again, there are the model rules of the American Bar Association that you must comply with, and there are many other sources of obligations as well. So you have statutes and regulations, like security laws and regulations. There are e-transaction laws. There's corporate governance legislation and regulations, things like that. There's also unfair business practice laws, and there are also some sector-specific regulations that your clients probably have to comply with. If your firm focuses on, for instance, the financial industry, you for sure better have your security program mapped back to things like FFIEC and PCI, and in some cases FISMA as well. And if you haven't done that yet, then that's an area that you should be focused on, making sure that your security program internally meets the rigors of those compliance mandates that your clients have. What that's going to do is ensure that when you have that client mandate come across, that not only are you able to check the box and meet the spirit of the control, but that your security program is actually up to snuff, and that you don't actually have to spend as much time answering those client mandates because the program's already built, and effectively you need to attest that your program is where it needs to be, rather than try to scurry and implement some controls in response to a client mandate. That sort of reactionary response is not really fruitful, and it can be wasteful from a resource perspective. And I know everybody listening to this has resource constraints that they must work within. There's also some common law obligations. It's been argued recently that there's some common law duty to protect data, and we've found that courts are starting to accept that viewpoint, where it's the term obligation to protect client data, obviously, but there are significant liabilities if you don't. There are also some rules of evidence that must be maintained, and I'm sure the attorneys on the phone could probably speak to this even better than I can. However, I know that from a cybersecurity perspective, not maintaining things like chain of custody over evidence and things like that they're the difference between successful litigation and unsuccessful litigation, or one that might even get thrown out of court. And so the same things apply to cyber as would apply to your normal case information and evidence information. And protecting that information and doing it in a by the books manner is again a requirement. And so that obligation is going to come from there as well. There are also those rules of professional responsibility. That's the ABA model rules that we were talking about earlier. There are several that are relevant to this conversation. The one specifically that we keep coming back to is 1.6, which is again that the attorney must exercise reasonable care of the protection of client information. And so the question we often get is, how reasonable is reasonable? And we're going to touch on that in a little while. Of course, you also have contractual obligations, and this is two ways. You have contractual obligations from your clients, and you should be issuing contractual obligations to your vendors. Your vendors are actually a significant risk point for you, and your clients are looking at you the same way. You're a vendor to them, and you're a significant risk to them because you have access to sensitive information. Now, the transitive property, A equals B, therefore, and B equals C, therefore A equals C, is true here. So if your vendors don't exercise the same level of security rigor over access to your environment as what you are, then your end clients are actually at risk because of that. So you need to do a very good job of third-party vendor management in order to really attest to your own clients that you've done the job from a security standpoint. And that really begins with baking security SLAs into your contracts with your vendors, doing vendor due diligence, and giving them audits or asking them to complete those same questionnaires. That's all very important. And if you're not doing it, I highly recommend you do it immediately. Many of those breaches that I had the logos up on screen earlier were the result of third-party risks. Target's the perfect example. Their HVAC vendor was the source of that original breach that cost them millions and millions and millions of dollars. And if that's the case for your firm, your clients are the buck will stop with you. They're not going to look at the liability on down to your third-party vendor. And they may look at that, and yes, the financial liability goes down to them. You might sue them for covering the costs, but you might still lose the client. And so that doesn't necessarily help you towards your ultimate goal of driving business through your firm. Additionally, you probably also have some self-imposed regulations, some privacy notices, or anything that your organization has developed in-house in terms of your own security policies or your general corporate culture around sensitivity around client information. Those self-imposed obligations also add up to the big picture of what is my obligation to protect client data. And all of those things kind of lead you down the path that you need to have a program that's focused on a couple things. On compliance, yes, you must be compliant with your client mandates, and on security at a higher level, such that going beyond compliance or stopping at compliance isn't really your goal. Your goal is security and not compliance. Compliance should be a byproduct of good security. And that perspective actually is pretty important, because that's going to, if you have that perspective, you're going to be able to drive down costs to implement controls, because again, you're not just looking at minimum compliance, you're looking at actual security. And while it might cost more to implement actual security, what you're going to find is that the work that you do later on down the line when you're trying to answer those client mandates, or later on down the line when an incident actually has happened, it's going to cost you much, much less to contain and respond to that stuff than what it would if you simply took a check-the-box approach. That's an important distinction to make there. So what's the data that you need to protect? I mean, obviously, you've got tons of different types of data within your organization. You've got information about your employees. You've got information about your clients. You've got information about attorneys or vendors that you might be working with, and vice versa. that attorney-client data is probably first and foremost in terms of overall sensitivity. That's obviously protected, and because it's so sensitive, because that stuff should not be ever disclosed to the public at large, must really be treated with a very high data classification standpoint, and the proper controls put around that to ensure that the confidentiality, integrity, and availability of the information is not compromised. You also have personal data within your environment. Again, a lot of that's going to come down to employee data in a lot of cases. You might also have personal data about your clients, depending upon what sort of law firm you are. If you're a B2B type law firm, or if you focus on plaintiffs, depends upon what sort of data you're processing. And that actually, that begs the question, have you performed a data classification effort or like a business impact analysis of your environment to learn specifically what types of information you're processing, where it's being processed and stored, and what sort of security controls are in place protecting that data both in storage and in transit? If you haven't done that data classification, this is going to be a really hard step for you to overcome, because you have to know what are you trying to protect in order to actually protect it right. It's likely that your firm processes all this information, but there might be some information which is much more sensitive than others, and that's information that, again, you need to know that so that you can set up yourselves for adequate security over that stuff. Of course, you likely have financial data and transaction records. That's going to be most relevant, again, to the M&A type attorneys, or perhaps those that are doing some sort of litigation from a financial institution perspective, or representing a financial institution. Super important to protect that, obviously, because that financial data is likely to be easily monetized, either stolen and sold in the black market, or used in the course of an industrial espionage campaign to prevent some merger, or to lower the IPO price of a firm that is floating an IPO. All that stuff could actually be the result of a breach of your firm, especially if you're the type of firm that handles mergers and acquisitions, or patent attorney or something like that. All that stuff is super important, and if you haven't done the due diligence of understanding exactly what sort of data you're processing and storing in your environment, you're not going to be able to protect it well enough. So that's really step one, is understand what sort of data you're processing and where you're storing it. So how reasonable is reasonable? That's a really good question, and there's a lot of different ways to answer that. And I think it's kind of interesting that it's left so ambiguous or vague in the regulation, and it does kind of leave room for some interpretation, so that you could state, we've done a reasonable job. Usually, what I've seen is that reasonable is built around some existing industry framework. In many cases, for the law firm community, that might be ISO 27001. That might be, again, the frameworks of your clients. So you may build to NIST or to PCI. In lieu of all of that, what we recommend to start with from a reasonability standpoint is build your program around the 20 critical security controls that SANS has published. And if you do a good job there of implemented at least the quick wins across all of those, then you probably have done a reasonable job. But again, it all depends on what sort of data that you are processing and how you're protecting it. What you're looking for are positive results. You want to ensure the availability of your client data so that if your attorneys need access to some information to support a matter, to support a case, they can actually access that when they need it. And you also need to control that access. And what I mean by that is need to know. Need to know and least privilege are concepts which are actually their core cybersecurity concepts, but I actually don't often see them employed at a very high level inside law firms. Usually inside law firms, the client data is it's available to either the entire firm or the entire practice within the firm, because there's a thought process that, well, we might need access to this information to support a matter, so therefore we should have access. And unfortunately, that actually brings with it a lot of risk. Locking down access to data is it's super important from protecting that data standpoint. I know it sounds kind of obvious, but again, most times I've found that there's a lot of looser internal controls around access to data than what you find externally. I liken it to a cookie with a crunchy exterior and a chewy interior. Once the bad guys get inside the environment, it's really easy to pivot around because there's a lot of really loose controls inside the environment. So you want to make sure you're controlling access internally and externally to data within your environment. Of course, you need to ensure confidentiality, integrity, and authenticity. Confidentiality means information being accessed by people who are not who are supposed to access it, and somebody who's not supposed to access it and gets it would be obviously a breach of confidentiality. You almost certainly have signed NDAs with your clients. So if that information is breached in the course of a cyber attack, then you have failed your obligations on that NDA, and that's probably prosecutable, or at least that's a cause for some contractual action to take place that could be a liability to you guys. Integrity in the context of cybersecurity simply means that that information you're processing is not changing, so that a bad guy couldn't go in and fudge the numbers in somebody's financial records to support a higher price for a merger and acquisition, as an example. There are many different types of examples along those lines. One which I found somewhat interesting was an organization had a employee generate a bunch of new and bogus employees in their system and then pay them. And so that cost that firm millions of dollars just in lost payroll that they weren't able to get back. And that actually is an integrity breach because the database that the employee records sit in, shouldn't be possible to change without having some checks and balances. And so not having that control of the integrity of that data cost that firm millions of dollars, and could probably do the same thing for you guys. In the harms that you're trying to avoid, of course, we're always trying to protect against unauthorized access. That's going to be pretty much number one. If we can prevent that unauthorized access, then the knock-on effects of the public disclosure of that information won't happen. The potential modification of records couldn't be possible because there's no access to it, and things like that. So obviously that's kind of first and foremost, prevent unauthorized access and prevent unauthorized use or disclosure or transfer. All those are basically the same thing. And of course the modification, again, is that integrity sort of stuff. The other thing there is accidental loss or destruction. So this is an interesting one because, again, law firms, in my experience, have lagged a little bit in terms of disaster recovery planning, business continuity planning, and things like that. And that's to their detriment because should there be some event which causes a lack of availability of client data, oftentimes that data is needed on the spot, right? You're in the middle of a litigation, and you've got some filing deadline that you've got to hit, and if you lose access to data for some period of time prior to that, then that could really compromise your ability to hit your filing deadline, which could get your case thrown out. So accidental loss or destruction of data is an availability thing, and if, let's say, your main data center had some network outage and you didn't have a hot online backup or something along those lines to allow you to continue accessing that data, then you're going to be in bad shape. And so some work's got to be done there from a disaster recovery standpoint. And what that all comes back to is that business impact analysis and data classification. What data do I have? What impact does it have on my business? And do I have the proper controls around it to ensure that I can access it when I need to, that it's not being accessed by people who shouldn't have access to it, and that it's not changing inappropriately. And so what's the legal definition of reasonable? What we found is that the legal standard for reasonable security is emerging. It's more focused on process of security rather than some specific technical requirement, such as a firewall or encryption or something like that. And I think that's actually the right approach. I personally don't feel that security, there's no single silver bullet or tool or one control that's going to solve this problem. But there is a process that if you rigorously follow it and you do a good job of lessons learned and treat it as a life cycle, then you're likely to be doing pretty good in terms of securing your client data. So the approach that I'm talking about here is first outlined in 01 under the scrutiny of the GLBA, the Gramm-Leach-Bliley Act, which were the document within the GLBA that speaks to this specifically is called the Guidelines Establishing Standards for Safeguarding Consumer Information. And that really laid the foundation for what we're talking about here from a process perspective. That process has also been adopted by a number of other organizations that are not necessarily within the law firm community, but again, they're either clients of the law firm community or they're influencers over it. So I'm speaking specifically like the Federal Trade Commission, FISMA, the Federal Information Security Management Act, the National Association of Insurance Commissioners. I know the National Futures Association also leverages that same sort of process approach. And there are many other examples along those lines. So if you start thinking about reasonable care and reasonable security as the process of self-assessment and implementing controls and learning from what you've done well and what you haven't done well and treating that like a life cycle, then you're going to be doing a pretty good job. So you're probably asking, what is the process? Well, here's a pretty good overview of what that process is, and I'll talk through each of these boxes here. So the first thing you want to do is identify information assets. So that's what I was talking about earlier when you think about business impact analysis and data classification. That all falls within that identify information assets. Because why? You need to know what you're trying to protect in order to adequately protect it. And if you have a gap in your visibility over what sort of information assets your firm is processing, then you have a gap in security. And I can say that with 100% authority. If you don't know what information you're processing, you're not protecting it well enough. Once you know what sort of information you have, you of course need to conduct periodic risk assessments. Those should be multi-pronged. I always recommend to have an unbiased third party perform those risk assessments, but there's also some value in doing internal self-assessment at least once a year, sometimes more frequently than that. Treat it as a readiness assessment for that third-party assessment. So do your own homework, launder your own clothes before you send it out for somebody else to look at. Because if you have done your homework in terms of patching, in terms of configuration baselines and stuff like that, which would fall out of a self-assessment, like you weren't doing a very good job of patching, that's going to save you time and money on that third-party assessment, and that's also going to make that third-party assessment more focused on helping you achieve a higher level of security and putting in some advanced controls that are going to be really effective, and that's, again, obviously to your benefit. Once you've done that risk assessment and start with like a current state assessment, where am I at today, then you move into developing and implementing that appropriate security program. And that should be based upon some framework. Again, that framework is likely best when it's tied back to the client profile that you're servicing. So if your firm focuses on the financial industry, then you should be building your program around something like FFIEC. If your firm focuses on the healthcare industry, then you should be building your program around HIPAA, for instance. And all of those are relevant from a security program perspective, provided you keep in mind that the concept that compliance is a byproduct of good security and not the other way around. Security doesn't necessarily flow from compliance. And so once you've done the work of implementing that security program, and again, that might be an area where you leverage a subject matter expert outside your own firm to help you with that, then you want to make sure that you're educating your internal staff. You're training people on security risks. You're training them on how to use controls. You're training on how to avoid being phished, or what's appropriate behavior to do online while you're using corporate resources. Things like that. All that training is super important because, in my opinion, the weakest point in the chain is the person that's not aware of what the risks are. Because if they're not aware, again, they're not going to be able to protect themselves. It's very similar to that initial box, the identify information assets. If you're not aware of what information you need to protect, you can't protect it. And if the users are not aware of what the risks are, they're not going to know how to avoid them. So that's a super important step to make sure that you take as well. Once all that's done, and your employees are operating their controls, and the tools are working, things like that, you need to monitor and test. You need to continuously monitor your environments because this is a global age, and the bad guys are in far-flung places in different time zones. And if you're under in the crosshairs of a advanced persistent threat based in China, they're not working 9 to 5 Eastern Standard Time. They're working, maybe they are working 9 to 5, but that's going to be in the middle of the night over here. And if you're not doing the monitoring in the middle of the night over here in the U.S., then you're going to miss it. And you may have 8 hours or more before you actually pick up some attack against your environment. And that 8 hours, again, could be the difference between you and a headline and you cleaning up a piece of malware on a single laptop. Super important. The other thing to think about is if you're not monitoring 24/7, and something bad happens at, let's say, 6 p.m. on Friday night, you're not going to see it until Monday morning, and that's a whole week and a time that somebody could be acting against your best interests. And you want to make sure you're testing those controls as well. So, of course, you need to monitor your environments, but you have controls built in place for things like protection or prevention and containment. You need to test those controls to make sure they're actually functioning and they're actually doing what their job is. And that should be a regular thing, at least a quarterly test, probably more frequent than that for the more significant security controls. And of course, you don't want to do that just blind and in a vacuum. The results of that need to be flowed back into the process so that you learn from it. You review and adjust. Those lessons learned are super important. Every time you have a security incident of any kind, that's got to be a step in the process of lessons learned. What went wrong that caused this, so that we can do better next time. The same thing is true if you deploy some new technology product in your environment. That's going to kind of kick this whole thing off again. If there's any significant change in your environment, pretty much want to start the process over and understand how that change impacts those information assets that you've got, update your risk assessment, update your security program, and train the differences, and monitor and test, review and adjust, et cetera. If throughout the course of this process you have engaged any third-party service providers, you want to make sure that they're doing their job as well. And that's information that you should be baking, again, into your contracts with them so that they have specific security-based SLAs that they have to comply with, and you should be monitoring their performance against that stuff. And if your third-party vendors aren't really aware of how to do that or don't really know how to answer those questions, it's time to look for new vendors. Because this is an established thing at this point where people that service information technology in the law firm community or really any of those industries, those vendors better know cybersecurity because they're a risk to you, especially if they don't. So from an ethical standpoint, what do you think your duty is from an ethical standpoint? There are a lot of different ethical implications to what we're talking about here, and you as an attorney have an ethical duty to protect your client data, protect your client from harm, and to represent them as well as you possibly can. And there are actually some idiosyncrasies to that which are somewhat interesting to the attorney, because a lot of times you're not necessarily thinking about technology when you're using it. When you're representing your clients, you're not thinking about the litigation support tool that should ultimately be transparent to you so that you can do your job. But in the end, you have to know how to use those tools so that you're best prepared to protect your client data. So there, in the professional conduct rules and ethical rules, there's a couple of key areas. Confidentiality, of course, we talked about ABA Model Rule 1.6 earlier. You have an ethical duty to keep information confidential. There is now a caveat to that, which includes taking appropriate steps to ensure the confidentiality of electronic data. So it's baked into your ABA requirement that you have to protect the confidentiality of client data. Now, many attorneys aren't necessarily personally responsible for implementing those sort of confidentiality controls, but those better be questions you're asking your information technology department, because your clients are certainly going to be asking you, especially if, again, if you're driving business into the firm, those new clients are almost certainly asking these questions. And that's information that if you have it at your fingertips, it's going to, number one, show your clients that you guys are highly focused on securing their information and you're doing your job there, and that might enable some business that you might otherwise not get. And of course, that's what we're all trying to do. You also have some ethical rules around competence. And according to ABA Model Rule 1.1, you have an ethical obligation to be competent about the technology you're using. And that can be kind of a challenging thing to handle, whether that's litigation support or whether that's the the base system that you're working within from a documentation standpoint or document storage or things like that. You have to know how to use those things securely. And if your firm's not providing you the training or the specific information about how to secure your client data, that's a question you should ask. You have a obligation according to ABA Model Rule 1.1 to ensure that you're competent in the security and the tools and securing the information of your client data. You better be asking that question because that's if there's a breach and you're found to be the negligent party, that could be obviously some significant personal liabilities for you as an attorney there. You also have an ethical obligation to enlist the help of an expert in the field if you don't personally have that competency or cannot reasonably attain the competence yourself. So that's where a subject matter expert such as TruShield would come in, help overcome that hurdle of understanding how to use the tools, how to implement them correctly and securely, and all that sort of stuff. There's an obligation to enlist outside help if that competency does not exist within the firm. There's also a supervisory obligation where there is an ethical obligation to appropriately supervise people who are working for you, as well as partners or vendors working to ensure that your vendors are following the professional rules of conduct. And that's not often done. So, we work with quite a few law firms, and we often do go through like a vendor vetting process where we have to show our security controls and things like that, but it doesn't happen every time. And that's kind of surprising to me. I don't, say to you guys, why didn't you ask me about our security when, we engage a new client that didn't ask. But that's a question you certainly need to be asking your third-party vendors. If they're not performing their own due diligence and they don't have competency in their own tools and they're not adequately securing your client data, you shouldn't be working with them. Only way you're going to know that is if you've gone through that due diligence process with your vendors and have done it at a level which scrutinizes their security controls. Again, not frequently done, not done all the time. Under common law, there's a couple of different liability areas. You obviously have malpractice liability. If you are found to be willfully negligent, that's obviously a bad thing. But if you're simply found to be ignorant of the controls, unfortunately, ignorance is no excuse of the law, right? So you've got to be aware of your malpractice liabilities and aware of what you should be doing to protect your client data at all times. You also have the fiduciary duty to ensure that misconduct around things like financial information to protect your clients, their well-being, that's being done to the greatest extent that you possibly can. If you're not doing that, again, there's liabilities associated with that. And it applies to digital data just as much as it applies to a box of paper documents. And that's actually a pretty interesting component of that as well. A lot of law firms that we've seen, they're starting to move away from this en masse, but we still do see paper documentation and locking that up in a locker and things like that. The same concepts apply to the digital information, and if it's not properly secured, then you're likely to be falling short of your ethical and common law obligations. So where do you go from here? How do you actually ensure that you're consistently providing reasonable care? First and foremost, what I recommend you do is take a good hard look in the mirror and perform that self-assessment of your own environment with the information that you've got. The reason that is because first and foremost, you know your institution better than an outside party would. And if there are glaring holes that you can pick up and fix prior to engaging a third party, then that's going to be to your benefit. I still highly recommend, in fact, I would say it's a requirement, engage a third party to perform a risk assessment once you've achieved that self-assessment and have implemented what is reasonable and feasible for you to. That current state assessment is going to help you identify where you're strong, where you're weak, and identify areas that need the most help soonest. That assessment should be done against some framework. Again, a lot of times we see ISO 27001. In lieu of that, I do recommend the SANS critical security control at the top 20. You might even just start with the top 5 and see how far you get down the line before you really need to engage a third-party subject matter expert. Again, the reason for that is your internal team is focused on keeping the firm operational and focused on keeping the lights on, so to speak. And there's not really a whole lot of time or bandwidth or expertise within some niche cybersecurity discipline, and that's really where you're going to get the most value of engaging a third party. And that framework that you're building against, again, should be based upon your typical client profile. So think about what sort of industries you service as a firm and build your program around that. There's some other recommendations we can give you as well. So in addition to building around a framework, what we advise you keep in mind are 4 key tactical areas that are the foundation of a strong cybersecurity program. And those 4 tactical areas are prevention, detection, containment, and eradication. And I say tactical because your cybersecurity strategy should be one level above this. Your strategy should be to implement a sound prevention capability, to implement a sound detection capability, etc. The tactical implementation of that, if you get this stuff correct, then you've probably done a good job of exercising reasonable care of your client data. So I'm going to quickly walk through this stuff. Prevention, within the prevention stack, you'll find things like firewalls, intrusion prevention systems, encryption, access controls, stuff like that. And historically, the security industry has been very focused on the prevention piece of the puzzle, and to the detriment of the rest of the stuff. So yes, you still need to do all of those prevention steps, but you need to be thinking about detection, containment, and eradication as well. Within the detection puzzle piece, you'll find things like intrusion detection systems. You'll find things like a SIM, a security information event management system. You'll find 24/7 monitoring via a third party such as TruShield. There's many different aspects of detection that can be implemented either technically or through process. Super important that you're doing that because, again, you're not going to prevent every single attack. There's going to be some that slips through the cracks, and if you can detect it before it becomes a major problem, then your containment is going to require much less effort, and response and eradication may require no effort. Containment is actually, while it's the third piece of the puzzle, it's actually something which you need to be starting on from day one. And that's not to say that you can't reverse engineer some containment strategies into your existing network, but the best containment strategies are built upon a segmented local area network and doing things like network segmentation and access controls and stuff like that. If you have really good segmentation of your network, then a threat which impacts Alice in accounting is likely to not impact Bob in IT. Because those are locally segmented off from one another, and the flow of information from one segment to another is scrutinized and controlled. That makes the containment process so much simpler. If you can simply lock it down to one narrow segment of the network, and then your work is half done, because there's no worry about it fanning out to databases that contain client information or things like that. And then you can move into eradication and cleaning up that handful of machines rather than every single machine in the environment. An example that I can give you there, we worked with a client in an incident response capacity where they had a phishing incident where some malware was delivered via a phishing attack, and because the containment strategy wasn't in place and properly constructed, that initial exploit against one laptop, what it did is it fanned out to every other laptop in the environment, because the malware was programmed to look at the global address list of that user's email and then send out that identical phishing email to everybody in the company. And every time somebody clicked on it, the same thing happened. And it ended up being like 5,500 laptops that got compromised as a result of that, which cost that organization millions of dollars to fix. You don't want to find yourself in that boat. So what we recommend you do is build a program that addresses all 4 of these control areas and does it in a manner that strategically aligns with what your client's risk profile is, and also in a manner that you can map it back to the different client mandates that you're going to get. If you do the job right for these 4 things, then those client mandates become much easier to answer, and also you've done the job of reasonable care. There's no court in the universe which would indict you for not exercising reasonable care if you can prove that you've got a good strategy and tactical implementation for these 4 capability areas. So, how do you do that? Well, of course, managed security services provider can definitely help. There's obviously that significant subject matter expertise that an organization such as TruShield would bring to the table. Typically, your third-party vendors that are in this space will have seen the problems that you're facing before. If they haven't, you should turn and run. But that subject matter expertise is going to help you shorten the cycle of achieving that reasonable care and achieving a sound security program. It will help you achieve a very high technical capability at a much lower cost, because that the third-party provider has borne the cost of the advanced technology and offers that out in a manner which is more digestible from a subscription basis than what you'd have to pay to go out and buy it yourself. So high technical capability, advanced security at a lower cost. And additionally, there's some transfer of risk with your third-party providers. When, for instance, we sign a contract with a law firm that we're going to be providing 24/7 monitoring and instant response for, and in fact, our errors and omissions insurance covers a lot of the risk that the client would bear should an incident actually occur. We have that liability to ensure that our clients are protected, and your third-party providers can help you transfer some of that risk yourselves. Now, that's not going to completely remove risk, right? There's no way to minimize risk down to 0. There's going to be some residual risk, and that's where things like cyber insurance come in. And breach liability insurance is important. If you don't currently have a cyber breach liability insurance policy, we recommend that you spend some time investigating that, because it's probably something you should have to cover things like notification costs when they do come up. So that's the end of the content for the webinar today. I'm wondering if we have any questions that I can answer. Looks like we do. Okay, so first off, can't we just get cyber insurance to cover the cost of a breach? So, I said it's super critical to have that cyber insurance, but cyber insurance is not a replacement for sound security. And an organization that says, we've purchased cyber insurance, therefore we've exercised reasonable care, is missing the point. You want to try to prevent the execution of your cyber insurance claim. And so the fact that you can cover your own financial liabilities by purchasing a cyber insurance policy doesn't help your clients at all. That might help you pay for the client notification when their data is breached, but that's not going to help them sleep at night. So no, cyber insurance isn't a good replacement for a sound security program. You still have to do the job of security. In fact, there are claims that are being denied because organizations are negligent with respect to their security programs. So don't think you can just go buy a cyber data breach insurance policy and your job is done. Unfortunately, that's the case. Another question. So if we work with multiple industries, do we need a process or plan to help us fulfill security needs for each one? So that's a really good question. So if you're a firm that works with multiple different industries, clients within different industries, then yeah, your security program needs to be mapped back to their compliance mandates, because they're going to ask that question at some point, one way or another. But what that doesn't mean is that you should be building multiple different compliance programs. Again, first and foremost, the way you should be thinking about this problem is build a sound security program that addresses those key components you talked about, that does so in a manner that meets the rigor of protecting the types of data that you have, and then you can simply do something like a requirements traceability matrix against the individual control requirements for HIPAA or FFIEC or whatever it is that your clients must comply with, and then that helps attest that you've met the rigors of those controls for your client base. So again, if you build a good security program, compliance should flow out of that, and a good cybersecurity program should comply with any regulation that's out there. And what I often say is that, again, because we have clients in many different industries ourselves, the language in PCI, for instance, the Payment Card Industry Data Security Standard, may be specific to PCI, but the control requirements, what they're really asking you to do, are actually really similar to what you'll find in HIPAA or in FISMA. I usually say it's the same eggs in a different basket. It's the same sort of controls, they just call it something a little differently. So if you've implemented a good security program, then mapping it back to the specific individual controls of these different mandates is going to be a lot easier for you to do. And that's something you need to be thinking about, because if you work in many industries, again, your clients are going to be asking you these questions. And if you can simply produce them a document which maps your information security plan back over to their compliance mandate, then that's going to show your clients or your potential clients that you really understand the industry. That's going to be business you're, again, much more likely to win. So let's see, any other questions? Looks like I got one more. If I'm already working with an IT security company, why should I switch to TruShield? So, okay, that's a good question. So I would say, first and foremost, TruShield is a company that's going to be very focused on helping your specific needs be accomplished. We're very concierge approach in that we take a lot of time to understand what our individual clients' pain points are and then develop solutions which matter to them. We're not resellers. We're not the type of organization that's going to try and foist a solution upon you that doesn't work. We're going to spend a lot of time understanding what your specific issues are so that we can help you overcome them. That's a difference. From a pure technical capability standpoint, our 24/7 monitoring platform takes a slightly different technical approach, which yields vastly different results. And they're to your benefit as well. We are able to pick up things like CryptoWall and other ransomware, which I'm sure the audience out there, if you're in the technology industry, it's probably happened to you or somebody in your environment. Other major service providers like TruShield can't really detect that stuff, and we've seen that time and again. We perform compromise assessments in organizations that are monitored by our competition, and we're finding stuff that they're not alerting on. So that's I would say why. Again, if law firms specifically, we have a wealth of experience helping law firms implement programs that are going to allow you to address the client mandates proactively, so that you're not spending so much reactionary time filling out checklists when you get new client mandates. That's not what you want to be spending your time doing, and we've helped many organizations do exactly that. We'd, of course, love the opportunity to help you do that. So with that said, if you do have any questions or comments or thoughts or want to talk about your specific security program, please reach out to us. You can reach us at TruShieldLink.com, where we have a resource center full of things like this webinar and white papers and other data sheets that are relevant to the law firm cybersecurity community. We also post cyber threat advisories, which give you indicators of compromise that you can plug into your own security controls to help you detect whether or not you've been popped by the latest malware, for instance. So I'd invite anybody listening to please check us out over at TruShieldLink.com, follow us on Twitter, reach out to me on LinkedIn, and you'll have access to a lot of valuable information that you wouldn't otherwise. So with that said, that's the end of the webinar today. So I appreciate the audience for attending. And again, if you have questions, please don't hesitate to reach out. Thank you.